to the First Home Show podcast, created for first home buyers. I'm your host, Melissa Barlas. I'm a property lawyer, owner and founder of Conveyed, and I've been a first home buyer myself. In this podcast, I'm going to show you in up to 10 short-minute increments what you need to know as a first home buyer, and I'll share with you all of my legal tips on how to purchase your first home successfully. Don't go it alone in the property market. We at Conveyed are here for you. Welcome to the next instalment of the First Home Show. I'm your host, Melissa Barlas. I'm the owner and founder of Conveyed, and I'm a property lawyer by trade. Oh, that rhymed. And today I'm joined by a very, very important guest. And I will now, I'll give you a summary of who it is. We are joined by the one and only Mark Errichiello. And Mark is a very seasoned buyers and vendors advocate, and he's been in the real estate industry for a very, very long time. So Mark, and Mark is also the director of Master Advocates. So he's based in Victoria. And Mark, I welcome you. Thanks for joining us on the episode.
Oh, hi, Melissa. Thanks so much for having me, and very kind introduction. So and that's a good tagline for you as well. It does rhyme.
It sure does. And you know what? I'm gonna be even kinder because I'm gonna run through some of your history and your experience just to help our audience understand who we're speaking with. So Mark is a very seasoned buyers and vendors advocate in Victoria, helping both investors and homeowners with their property goals. He is the owner and founder of Master Advocates since 2014. So he's been around for a very long time, and prior to that was a real estate agent as well. He is on the board of REIV. And he's also the REIV Buyers Agent Chapter Committee and Members Council Delegate. And he's also won awards, in fact, by the REIV for excellence in his field. He was a finalist also as a Buyers Agent of the Year in 2021, 2022, and then 2023. And then subsequently in 2023, he was elected to be on the board. So again, welcome, Mark. And I guess my first question to you is, how did your career start in real estate? Just briefly.
Thank you. Yeah. There's a few things there that different experiences, which has been fantastic. But my career started following my father and brother into real estate. So my father, I'm a second generation real estate agent, and always born and bred and lived in Melbourne. So we were raised in Brunswick, and family. And my father was in real estate since as long as I can remember, and my brother joined him straight out of high school, essentially. By 2000, I started in the family business. They were operating a franchise of Rain and Horn Real Estate in Ascot Vale, right near the Flemington showgrounds and racecourse. So I started in property management, moved into sales and auctioneering, and met my wife Michelle in that business as well. So her experience was property management, and that's where we co-founded our business by 2014 together.
Oh, very good. You guys, I'm sure, make a very dynamic duo, you and your lovely wife Michelle.
Yeah, we've been working together since 2002 now, but definitely the strength behind the business and helps me a great deal.
Amazing. So for our listener, what I wanted to talk about with Mark today is an incredibly important topic that Mark has quite a lot of experience in, especially because he's also been a real estate agent himself. You've been a real estate agent yourself, Mark. So what I want to talk about is exclusive agents authority. So the document you sign up with the agent to appoint them as an agent to represent you on your sale. that is the document that we want to talk about, because it is foreign to a lot of people. A lot of people just they get comfortable with an agent. They give them this thing called an exclusive agent's authority. They accept the terms for what they are. They might talk about commission and marketing fees, but then perhaps the conversation doesn't go beyond that. And then they just sign this exclusive agent's authority. But what a lot of people find is the agent can rely on that in circumstances, or in one circumstance where you might want to then move on to another agent if you're not happy with their performance. So, which can leave people a little bit stuck. So I guess
Yes.
I just wanted to find out from you and your perspective, Mark, what do people actually need to look out for when it comes to exclusive agents authorities, and how can they better manage their risk? And perhaps you could start by identifying what that document is more succinctly,
Yes.
and then perhaps going to how, what people need to look out for.
Yeah, so look, throughout my career, and every state and territory has different legislation and different rules about what needs to be included. The authorities may look different, and that's from the buyer's agent perspective, from sales and leasing perspectives as well. Throughout my career, when I've been involved in real estate businesses in the past as a sales agent, auctioneer, and now vendors advocate, this is the process we run through with clients, making sure they understand each part and the rules of engagement before signing an authority. Now, when I was with Rain and Horn, they were always REIV members, and still now I use REIV contracts, not just shining the light because I'm involved in the board there, but before being on the board, I was involved in sales chapters and buyer's agent chapters there. And the forms is a part that REIV have. Some agencies use different authorities. So some agencies create their own. If they're not REIV members, they may have a solicitor or someone prepare an authority for them, or their own brand. They may have different franchises, or different brands may create a template authority. So it doesn't mean that the authority is the same in every agency that you look at in your state. But for example, if you use an REIV or a Real Estate Institute of Victoria authority, and they have forms and digital platforms that run this, you've got exclusive auction authorities for essentially your auction process and campaign, and then you have private sale and private treaty authorities, and sometimes private tender authorities, which is essentially private sale, but you're closed bidding and an expression of interest tender date. So the main things to look out for, and I feel welcome to stop me and ask any questions, because I'll talk underwater with a mouthful of marbles. So, but
No, please continue on.
Yeah, main parts to look out for is really asking the right questions through the appraisal process. So when you're actually getting agents involved, doesn't matter if it's residential or commercial real estate, when they're putting forward their proposal and their estimate selling range, if it's residential sales, the legislation will state that what the estimate appraisal range that goes under the agent's price estimate section, or agent's estimate of selling price section on that authority, they should be then displaying that to the consumers, to the prospective buyers, on their indicative selling price, what's called, if you're looking, say, on realestate.com or one of the major platforms, Domain, and you're seeing the ad there with a statement of information link, that agent's estimate is the same estimate that they've put forward to the owner as an estimate range that they should be selling the property within, or that they believe it's worth. It's not the owner's reserve price, and the owner doesn't have an obligation to set their reserve price in that range unless the owner has a fixed price that they've determined, and they've notified the agent of that price as well. Then the agent's got an obligation to market from that price or greater. Okay, so that's that whole topic that keeps being raised about what's fair quoting or underquoting, scenarios. The owner doesn't have an obligation to determine a reserve price at the beginning of a sale. They've got every right to, make an informed decision based on market feedback. And then if they know that there's a price they will not accept below a benchmark, and buyers are expressing offers and terms, so the terms should be acceptable as well, not just a price with subject to finance for 30 days. If they're rejecting the terms but not the price, that's fine. They haven't got an obligation to set a reserve at that point. Without getting off track, there's a section on each authority that states the vendor's reserve price. That's where, if it was a private sale, there's some expectations that if you're aware of a price as a vendor when you start selling, you should set that, and the agent can do a fixed dollar amount based on the vendor's reserve price in the marketing to the public. Or if there's no reserve price set, and commonly with auctions there's no reserve price set at the beginning of a campaign, the owner may go by the agent's lead with the agent's estimate that they advise them that they would be achieving. Say, for example, 1 to 1.1 million is the agent's estimate, because their estimate range can't be more than 10%, not a cent greater than 10% from the lower range of the agent's estimate. So 1 to 1.1 million, for example. Then by the auction date, there would surely be feedback, some interest expressed. The vendors have the right to say they're not going to accept offers or negotiate and consider offers prior to auction. But by the auction date, they should set a reserve before the agent goes out to perform the auction. With private sale, in some cases you find they've set a reserve price to be advised as well, and the agents will advertise based on their estimate or their estimate selling range. But I find there's probably an opinion out there that if the vendor's offered a price in a private sale and then declines it, they should respond with a counter offer or reserve price that then gets publicly advertised as well as a range, as a price, and it can be above as a range from that price or a fixed price, but they shouldn't be going off the agent's estimate if that's lower as well.
Okay. And why is it important for a vendor to have their reserve price set in the exclusive agent's authority? What's the actual benefit to them?
Well, I would say in a reserve price situation, say for an auction campaign, personally, I wouldn't determine a reserve price at the beginning before I've had time to do some, have an informed and rounded consideration of market sentiment for my particular property, market feedback for my particular property during the campaign, and some expressions of interest that may arise or questions. And then the agent can help you by week 1 or 2, help you build that informed decision to set your reserve price. But if you set it at the beginning without having any knowledge other than the few weeks of interaction that you've had with agents doing appraisals and telling you their opinion or their estimate price, you're not that informed. And if most agencies do the right thing, but say if they informed you to set your reserve price a bit lower than you would expect, or that you'd be satisfied with, and then they came with an offer at that range but you weren't satisfied to accept it, the agent can, you can at all times withdraw from selling and decide you want to change your reserve price as a vendor. That's fine. But the agent then, if you read the fine print and details and the conditions of their eligibility for commission, they would have all rights. If they said, okay, you said you want $1 million, here's an offer at $1 million unconditional on contract. If you choose not to take it, the agent does have the right to ask for their commission because they've achieved what you've set in the conditions of the authority. Right. So if you're not comfortable with the price at the beginning, if it's private sale or auction, then you don't need to decide your reserve price at that time. As there is an expectation with private sale that you should have a price set, a fixed price, but there is an allowance to start with the agent's estimate and then set a reserve price, either from the bottom end of their estimate and greater, or have a fixed price dollar value, and you can still set a price, in a response in private sale situation as well, in a response to offers. But certainly if we're going back to auctions, there's no obligation for them to set a reserve price on the agent's authority at the beginning of the sales campaign.
Okay, so the agent sells the property right, and so if the agent sells the property at below the reserve price, do you still need to pay agent's commission to the agent? Is that how it works?
You would generally, when the time comes with in Victoria, you've got the contract of sale and the Section 32 vendor statement. Once the offer's prepared on that, and the owner's accepting an offer that's been signed on a contract. Before the owner executes that contract, they would have an understanding of reserve price at that time. If they're going to accept it, that's the new reserve price. If they're going to accept that offer, and you would, as an agency, for your own due diligence and compliance within your own office process, you would have the authority amended at the same time to match that price on contract. So that there's, so if the agents, for the agent's best practice, they should be doing that. So they're eligible for the commission for the agreed sale price as well. And that's fair to the agent and fair to the vendor to have that document amended at that time.
Sure. Tell us a bit about exclusivity periods under an agent's authority. Why that's and why that's important for vendors to know.
Yes, yeah. So with private sale, it would generally state that the exclusive authority period is, say, 60 or 90 or 120 days, or sometimes longer, whatever you agree to ethically with the agent that you're appointing. During that period, they are your exclusive agent to represent your property. Now, if you can withdraw your property from the market at any time, or that agency, if you think you've got, if it's a reason due to conduct, there might be legal pathways that you can have the authority withdrawn and voided and terminated, but that you'd need to follow that process. Otherwise, the exclusive period would state that they're your only agent that can represent you during that time. If the property was sold during that exclusive period via another agency, there could be risk of being liable for double commission, because they'd have eligibility for their own commission during that period. It'd be up to yourself to prove the reasons with evidence otherwise why they're not eligible for it. Then with auction authorities, generally it would state a period of exclusive authority so many days after the auction date. So it's automatically exclusive up to the auction date, which may be 4 or 3.5 or 5 weeks time. Then it would state maybe 45 or 60 days commonly after the auction, because if it passed in at auction and you're still willing to work with that agency, it would automatically be an authority exclusively for private sale, as soon as the property's passed in or doesn't sell. So during those exclusive periods, you need to make sure you've got the understanding right of the terms and conditions about the exclusive authority of the agent, and if different reasons that they may accept for you to withdraw without any penalty or liability for commission. As well, then there's a continuing authority period, which means automatically it's like a periodic basis. It just rolls over. As soon as the exclusive fixed period expires, it rolls into that continued authority period automatically until you notify the agent otherwise. And so during that, that's like a general open authority, because there are general authorities you can see sometimes where it's not common anymore, but agents may agree with an owner that they've got multiple agents working on a property, which can work against you as a vendor, or even rental providers as well. But they might have a general authority for all agents saying, if you achieve what I need, you'll earn the commission. Otherwise, there's no fee. And there could be some marketing expenses paid by owners in that period as well. But general authorities definitely are not as common or widely accepted.
Right. So if, let's say, you sell the property, the agent sells the property during the exclusivity period.
Yes.
They obviously get their commission from that sale at the right time. If you're within that exclusive authority period and you decide you're not happy with the agent, then you say, I want Joe Smith down the road to do it for me during that period. What is the consequence to the vendor of taking that action? Is it that they have to pay, or technically the agent can enforce the authority to require the vendor to pay not just the new agent their commission for the sale, but also the original agent?
Yeah, look, if they haven't got reasonable grounds, and usually it's to do with conduct, and you'd need evidence for that. And if the agent's got every right to challenge it, you'd need to take that to court sometimes, or get a legal representative to help you mediate. But if you haven't got reasonable grounds, then the agent is eligible for commission during the exclusive period. And then sometimes you look at the authorities, and there's a period that states, if we have evidence of introducing, as an agent, if the sales agent had evidence of introducing a buyer that ended up being a successful purchaser, if the agent had on their database reference of introducing that purchaser to your property during their period of management, and then you had selected another agent, you took the listing away, property still wasn't sold, you provided the authority with a new agency, and that new agency sold to that same buyer, there's a period of time that they can still be eligible to claim commission, even if it was beyond the exclusive period. Sometimes it might be, if we introduce the buyer during the exclusive period and they purchase, for example, within 6 months of the exclusive period, that could be terms that you've got to look at the fine print. It's all generally documented. For example, the REIV, the Real Estate Institute authorities and forms, they're all processed and reviewed and updated regularly by solicitors that represent the institute for the forms, and that's to make sure that it's one, best practice, protecting the agent and the vendor as well ethically within legislation. But
I think it goes back to your point about, like you say, check the fine print, and not every agent's authority is the same. It goes back to that point. You cannot treat it as one fits all. It's a bit like us reviewing a contract of sale. You cannot assume it's the same for every property transaction. So you really have to read the fine print. So really appreciate
you're welcome.
The discussion. It's very interesting, because this is not something that's widely talked about. We talk about market updates, we talk about the legal side of things with respect to actual contracts of sale and vendor statements and the transaction as a whole. But when it comes to agents' authorities, I feel like that's something that deserves conversation for people, so that they can be more prepared, so that they can ask the right questions to the agent, understand what it means, what exclusive agents authority means, and make sure that they're choosing a fair period that's not going to lock them in for, say, 120 days plus, for example, which can be quite,
or
quite,
like,
quite
12 months may be unethical. But so even if the agencies aren't using a standard real estate institute authority, they may have their own created, they'd still be bound by legislation and the sales acts to sell property, and estate agents acts. But sometimes people get creative and in sales and negotiations, and they may put in extra terms or author extra conditions that haven't been approved by a solicitor, or the vendor or the agent's solicitor haven't reviewed that extra condition. I think if it's outside of your legal rights, they're the type of things that you could challenge as being unreasonable when you want to exit and get legal advice to review it. But if you're a seller and a vendor, and you're already appointing a solicitor to prepare or conveyed, for example, to prepare your contracts of sale and Section 32, before you sign an authority, see what they may charge to review that authority for you. That may be a good practice, best practice, because you already have a legal representative for this sale, and just have them review the authority. Some may do it as a complimentary, depending how many authorities you're wanting to read. But I think it's something worth asking.
Absolutely, and even for yourself. I mean, you've got so much expertise dealing with exclusive agents authorities, having been an agent and now being a vendor and a buyer's advocate. All the more reason for you as the listener to pick up the phone and actually speak to Mark or myself about the agent's authority. And as being a vendor advocate, you're acting in the best interests of the vendor who's selling, especially if you're a vendor selling for the first time, because this is the first home show. It's incredibly important to make sure you're doing things right from the outset. Otherwise, you could be stuck later on. So really appreciate all the sentiments that you've mentioned today about agents' authorities. Lastly, Mark, how can our listener contact you?
Yeah, no, that would be a pleasure. Always happy to have a chat and share some advice. So Our website is masteradvocates.com.au, or can contact me directly on my mobile 0408 988 118. So yeah, no, thanks, Mel.
My pleasure. Well, guys, that's a wrap for us today. So thank you, Mark. Thank you if you're listening to this. Thank you so much for supporting our podcast, The First Home Show. My name is Melissa Barlas from Conveyed. Our website is www.conveyed.com.au. Lots of resources, and the podcast is on the website as well. But for now, thank you, Mark, and to you, our listener, happy house hunting.
Thanks, Miss.